Good morning, um, and thank you, Dr. Walia. So the topic today I'm going to be speaking on, this is the activist case. It's a year-old case, so a lot of you may have heard of it. My interest is not to grill the facts of the case, but actually talk a little bit about what happens after the Supreme Court decision in the United States came down, and what is the aftermath of that case? How is this going to affect the interface between intellectual property and antitrust? As we all know, those two are the competing forces. One wants to monopolize, the other is against monopoly. So what happens with this change in standard that the Supreme Court has now instituted? And so let's go through that. I'm going to go through some facts so that we set the case up. Basically, the case relates to a typical ANDA litigation wherein a patent holder company is the branded drug, and you have a generic, and then the generic files an ANDA application under paragraph 4 in which they have to declare the mother patent, that is the branded patent, as invalid. Clearly, the branded patent owner is going to sue the generic owner, and then there is a settlement that happens, okay? And because you want to settle the patent infringement litigation, the generic owner may delay the entry, and also there will be a payment that may happen from the patent holder to the generic, which is called the reverse payment, because it's kind of counterintuitive to think that you are the owner of the patent and you are paying the generic. And then there might be additional terms that you help us with marketing, etc. And so the FTC's view has always been that that is antitrust violation, because you're colluding with your competitor. The competitor agrees to not enter the market. The competitor agrees not to and help you out. The competitor basically gives you a free hand. And so the FTC has always maintained that this is an antitrust violation. And there have been rulings from various circuits in the federal circuits in the United States where different standards have been applied. But the by and large prevailing standard prior to activists had been the scope of the patent test. In essence, what it means is, look, if you are going to be within the scope of the patent as a result of your settlement agreement or any other agreement, you're fine, because you're not exceeding the maximum scope that the patent is going to allow in terms of your monopoly. So, sure, you go through a settlement agreement, that's fine, because in vacuum it might be an antitrust violation, but when you look at the patent scope and if it's consumed within the patent scope, there cannot be an antitrust violation. So that was the prevailing standard, that you apply the scope of the patent test and you're fine. There have been competing decisions. For example, the Sixth Circuit has talked about that this is an unlawful restraint of trade. It's a prima facie evidence of an unlawful restraint of trade, or that it is per se illegal restraint of trade. So much higher standard is what they've applied. But then, so one is the quick look doctrine and the other is the rule of the reason doctrine. The quick look doctrine is basically the presumption that there is an unlawful restraint of trade. And the rule of the reason is that you balance the anti-competitive and the pro-competitive forces out and then make a decision whether the practice is anti-competitive or not. Also, in the quick look, you can rebut the presumption of a restraint. So that is a higher standard. Obviously, the FTC loves that. So we are talking of three standards: scope of the patent, rule of reason, and the presumptive quick look. The FTC loves quick look. The scope of patent was the standard externally available, which is what everyone was operating under. And the rule of reason was there somewhere in between. And so the FTC started out at the bottom and said, we want the quick look to prevail. Scope of the patent exists, that test exists, and the Supreme Court said, okay, you know what? We'll merge those two and come at the rule of the reason. And so the activist decision basically says that rule of the reason should prevail as opposed to the scope of the patent. So now let's see what happens when we do something like that, okay? And this is the actual facts of the case. Solvay had held a patent for androgel, which is a testosterone gel, and Actavis filed an ANDA application based on that, which is a paragraph 4 is what they used, so which means they had to declare the patent invalid, which they did. I mean, they filed their application, and so they were sued by Solvay. Then they settle, and the settlement terms are such that, the patent term, the term of the settlement was smaller than the actual expiration date of the patent by about 5 years. So they were within that framework. And then also Actavis was to promote the branded drug, androgel, to physicians, and then they were going to be paid by Solvay to a tune from $19 to $30 million for 9 years, every year, that is. So FTC, ever so willing, went ahead and sued Actavis and Solvay. So the 11th Circuit immediately dismissed that, saying that, we apply the scope of the patent test, and unless there is a sham litigation or fraud in obtaining the patent, in other words, you devise the litigation in such a way that you then say, okay, now we want to settle, and then the settlement is really, the collusion that you wanted to get to, but you're using this as a sham litigation to do that. So they said, you're immune from antitrust attack so long as its anti-competitive effects fall within the scope of the exclusionary potential of the patent. In other words, as long as you're within the scope of the patent, that test applies, get lost. So the case goes to the Supreme Court, and Justice Breyer says, no, you don't need to apply the patent monopoly and look the antitrust test. You don't need to apply the antitrust test with the background of the patent monopoly. You have to apply it almost in vacuum, if you will. And then he gives 5 reasons as to why that should be the case. And here are the 5 reasons. They don't really, they matter, but they don't, it's not relevant for our discussion. But the basic point was, Justice Breyer's point was, you must analyze that settlement under the rule of reason, which is the balancing of competitive effects. That's what you must use. So he shifted the standard, and so the basic point was the relevant anti-competitive harm is that large and otherwise unexplained reverse payments seek to prevent the risk of competition. So large and unexplained is the standard now, whatever that means, right? And so then the case was remanded to the lower court. But the important part is the dissent. Now, because of what the majority said, look what happens, these are the scenarios that Chief Justice Roberts is painting, that would happen, because you have now moved from the scope of the patent to the rule of the reason, it's basically unsettling the relationship between patents and antitrust law. You're on one hand saying that, a regime where court ignores the patent and simply conducts an antitrust analysis, which means what? When a patent is granted at the patent office, it is considered presumptively valid. What this does is it basically says you apply the antitrust test in absence of the patent. In other words, as if the patent did not exist. In other words, let's treat the patent as presumptively invalid and now see what happens. Do you really come up with an antitrust violation? And that's saying that the patent grant is not sacrosanct, but it is. So this is almost like undermining the patent office's authority. You're essentially saying that this patent is not valid. And it could create a lot of problems, and that's where the practical objections is what matters here. And I'm going to read them. It impedes settlement of pharma patent infringement lawsuits. You don't want to settle a lawsuit if you think that you're going to be charged with an antitrust violation. That's a problem. Generics may be less likely to challenge the patents in the first place. And the third point is more important. Logic cannot be limited to reverse payments. Large and unexplained, that is the standard that the Supreme Court uses for reverse payments. You can't simply restrict to that. It's going to spill over into other things when other considerations are used instead of these large and unexplained reverse payments. And then there is a possibility of absurd result. What if you declare that there is an antitrust violation and actually the litigation progresses litigation progresses and you find that the patent is actually valid. So on one hand, you're saying, thank you, on one hand you're saying that the patent is valid, but on the other hand you're saying it's an antitrust violation. What prevails? You know, I've got 5 more minutes, but let's, so then there are developments subsequent to this case, and you know, the FTC has really developed teeth on this. So there is this one case in which they are saying that a no authorized generic settlement is covered by activists. In other words, there was no large and unexplained reverse payment, but still it is covered by this case. There is another case where sham patent litigation was used as a basis, along with the no generics settlement. There's several cases in the Third Circuit where a variety of bases are used to trigger this rule of reason analysis. So the problem is, this whole discussion has happened in the pharma litigation and a related litigation space. But there is no basis to say that this cannot spill over into non-pharma litigation. There is simply nothing that says, well, you know, this case can only apply to pharma litigation. You simply cannot do that. There is no way to stop at quote-unquote large and unexplained reverse payment. You can have other considerations. And then the final point is, so here's my point, you know, how far will it extend, you know? And so then the final point is should this only be related to patent litigation? Should this also not be considered during a licensing opportunity? And Chief Justice Roberts actually pointed out that if you license your patent to someone, you definitely reduce the likelihood of that person bringing a lawsuit against you. So you have basically taken an anti-competitive action. You know, so when you start thinking of a patent as presumptively invalid, even a licensing agreement could be scrutinized for antitrust violation. And then finally, why just patents? You know, why not other IP-related issues, trademarks and copyrights? So the thing that, you know, I would like you to remember is, when you're counseling clients, there are 3 things or 4 things you want to remember. One is, maybe you should have an antitrust compliance program that includes the activist considerations tailored to each client's industry, even if it's a chemical industry or your, you know, electronics industry. Any settlement agreement, patents or otherwise, involving patent rights should be reviewed by antitrust counsel. Maybe you want to, you want to have an opinion of an antitrust counsel to help you to make sure that there is not at least a willfulness issue. And then infringement lawsuits to defend patents perceived as weak by the FTC may be subject to antitrust attack, you know. So this is the sham litigation issue. And private litigants may follow the FTC's lead and then consider this as a counterclaim. And then the 4th point, obviously, that it extends to other forms of IP. So these are the 4 points that you may want to remember, that there is an antitrust teeth that have been developed by the FTC. So when you're counseling your clients, think about this. The rest of the case is simply movement of the standard from scope of the patent to the rule of reason. Thank you. Is time? Okay.